We have a terrific panel to kick things off. Let me start with our moderator, Shannon Eagan. Shannon is a partner in Cooley's Palo Alto office, where she serves as both a partner in charge and head of the business litigation practice. And she represents corporations and individuals in complex disputes and litigation and securities class actions, as well as SEC investigations and SEC actions. Welcome, Shannon.
Thank you.
Next up is Tom Heck, a partner in KPMG's forensic practice. He has over 17 years of experience in assisting clients with a wide range of forensic investigative services, including fraud risk assessments, anti-bribery, and corruption services. So glad Tom is with us here today. Welcome, Tom.
Thanks, Bruce.
Next, Justin Lichterman, a director and associate general counsel on the special investigations team at Meta, formerly Facebook. He focuses on matters involving corporate entity level risks and adherence to laws and regulations, and he was previously an attorney himself in the SEC's Division of Enforcement. Welcome, Justin. Britt Whitesell Biles is a partner at Womble Dickinson. Previously, she has served in a number of senior legal roles, including at the SEC, where she was Assistant Chief Litigation Counsel in the Enforcement Division, at the White House, where she was Special Assistant to the President and Associate White House Counsel, and also at the U.S. Small Business Administration, where she served as General Counsel. Welcome, Britt. Finally, our panelist from the SEC is Kate Zoladz, an Associate Regional Director who oversees the SEC's LA office's enforcement in Southern California, Arizona, Hawaii, Nevada. Started off as a staff attorney in 2010 and then spent time in the asset management unit after that. Kate, it is great to have you with us. Thank you. Shannon, let me turn over to you.
Thanks, Bruce. Good morning, everyone. It feels like whistleblowers are gaining more and more celebrity status, so I think this is a fun way to kick off the morning. And I thought I would turn it over first to Kate to talk about how busy the SEC's been in this area, particularly this year, and also to kind of level set for those who need to be reminded about the program a little bit. So Kate, why don't you take it first?
Great. Thank you so much, Shannon, and thank you, Bruce. Let me not forget to give my disclaimer because I will forget. So the views I express today are made in my official capacity as the Commission's Associate Regional Director for the Enforcement Division in the Los Angeles Regional Office, but do not necessarily reflect the views of the Commission, the commissioners, or the staff. So yes, let me start off with a little table setting, mostly because it's 8:10 in the morning and you may not remember what the whistleblower program is. So first off, the whistleblower program was established by Congress in connection with the Dodd-Frank Act. At a high level, it authorizes the Commission to pay an award of 10 to 30% of amounts collected, where an eligible whistleblower voluntarily provides original information that led or significantly contributed to a successful enforcement action where monetary sanctions exceed $1 million. So just in terms of process, the whistleblower has to apply for the award. The Office of the Whistleblower within the SEC reviews each application and makes a recommendation as to whether the applicant is eligible, and if so, where in the 10 to 30% range the award should fall. But even though the Office of the Whistleblower makes a recommendation, all of the awards have to be approved by the Commission. So critically, the payments come out of the Investor Protection Fund, that it's not from disgorgement or other funds that are intended to compensate victims. The Dodd-Frank Act also expanded the prohibition against whistleblower retaliation. So an individual can bring a private right of action, but the Commission can also bring an enforcement action against a company for violation of anti-retaliation provisions. Finally, the Dodd-Frank Act also provides that an enforcement action may be brought against a company who takes any action to impede an individual from communicating directly with the Commission about a possible securities law violation, and that can include enforcing or threatening to enforce confidentiality or other agreements.
And so, Kate, this year we saw the largest ever award. What can we glean from that? When you look at the order, it is redacted, and there's very little to sort of know from that, but I thought you had some interesting takeaways from that, but maybe you could tell us sort of what the award was and what you think we can glean from it.
Sure, and you're right, I can't say too much about it, but it was a nearly $279 million award. to a whistleblower whose information and assistance led to the successful enforcement of an SEC action. So it was the highest award in the SEC Whistleblowers Program history, and it more than doubled the previous award, which was for $114 million in October of 2020. Just notably, there was also a $100 million award in 2021. A couple takeaways that I thought were interesting. So I thought it was notable that the whistleblower's information didn't actually prompt the investigation, the opening of the investigation in that manner, but rather it expanded the scope of a previously existing investigation. And again, the whistleblower provided sustained assistance over time, including multiple interviews and written submissions. So just kind of more generally, I thought I'd also talk about the most recent annual reports. So this would have previously dated the most recent award, but it was the second highest year for the SEC's program in terms of the dollar amounts and the number of individuals. And interestingly, we've continued to see an increase in the number of tips that the SEC receives. So fiscal year 2022, the Commission received over 12,300 whistleblower tips, which was the largest number of whistleblower tips received in a fiscal year.
And so we've had some rule amendments lately. Justin, could you walk us through some of those amendments and perhaps some of the differing views about such amendments that we saw at the Commission?
Sure. Earlier this year, the Commission did amend some of the rules relating to the whistleblower program, and Commissioner Peirce dissented, so we'll talk a little bit about that. There are two main changes in the rules, but overall, the goal of the rule changes was to ensure that the SEC rules continue to incentivize rather than discourage whistleblowers to come forward. And that's sort of a theme that runs through these rules, that runs through the Commission's approach to various things, and how I think it's thinking about the whistleblower program. Maybe Kate can back me up on that, I don't know. The two primary changes are these. First, the SEC limited its own authority to reconsider the amount of a whistleblower award. So the statute gives the SEC Commission the commissioner's discretion in reviewing the awards that come from OWB. And now the commission can only adjust those awards up. It cannot adjust those awards down. Commissioner Peirce's dissent was very interesting on that. I found it persuasive because she said, and I think these are her words, that the commission is disavowing authority it never used. But clearly, when you decide to limit your authority to reduce awards, you're going to incentivize more whistleblowing because OWB's award is the minimum you'll get. You'll never be reduced from there. The second change is a little more technical or Byzantine, as Commissioner Peirce described it, and it involves an expansion of the scope of when the SEC's program can give an award to a whistleblower for recoveries in non-SEC actions or related actions. It used to be that a related action is defined in the statute. It has to be certain agencies or have certain limits, like for state actions, it has to be only criminal actions. But it used to be that the SEC whistleblower program could only issue an award if it had the more direct or relevant connection to the action. And now the expansion of that definition allows the SEC to grant awards where the other agency's whistleblower award program would have resulted in a smaller fine, or is a discretionary program, and it's capped at $5 million. So as long as the award under the SEC program wouldn't have exceeded $5 million, the SEC can award based on recoveries in a related action. So meaningfully lower award, discretionary, capped at $5 million. So what's the practical implication of these two rule changes? Probably nothing, as Commissioner Peirce says. The commission limiting its own authority doesn't really affect companies or defense counsel. We don't get an opportunity to advocate there anyway on whistleblower awards. And under this change to the related action rule, well, again, the commission's going to decide that itself if something's related. Plaintiff side whistleblowers, counsel might advocate a little bit more about why they should get to recover. but I think on the whole for the defense bar, there's not a whole lot of action there. Some other agencies that I thought might be interesting to watch to see if they result in more awards from the SEC are the IRS, because most of its whistleblower awards are discretionary, and often securities fraud cases involve a tax evasion element, or the CFTC. I just noticed that the CFTC, since 2014, has issued $330 million in whistleblower awards, and the SEC awarded that much nearly 2 weeks ago in one case, or nearly that much in one case. So it'll be interesting to see. I consider that meaningfully lower. It'll be interesting to see if there's any awards for CFTC actions, given some of the historical rivalry between those agencies.
So, Britt and Tom, tell us a little bit about some of the big cases that we've seen this year, including at SCOTUS and others. Does somebody want to kick it off?
Sure. Well, the Supreme Court granted cert in a case involving UBS, and it's actually not directly under the Dodd-Frank whistleblower rules. It's a Sarbanes-Oxley whistleblower case, and it turns on what a whistleblower has to show in a retaliation case. The Second Circuit had ruled that the whistleblower must show retaliatory intent because of the plain language of the section Sarbanes-Oxley talks about because of, and it uses the word discriminate. So a panel on the Second Circuit took that to mean that there is an intent requirement. Other circuits have reached different conclusions, or conclusions that are slightly different, enough that the Supreme Court has taken it up, and it's caused quite a hubbub in the plaintiff's bar for whistleblower retaliation, and also has invited amicus briefs from various congressional offices, including Senator Grassley's, who's a whistleblower advocate. So that decision's coming down the pike in the fall after it will be heard. So there will be much to see on what comes out of the case and what that changes, if anything, for retaliation claims. But there's also an RBS case that the Second Circuit recently heard too, that is a 21F case, right, Tom?
Yeah, and I have two cases that are recent in the last couple months that I find interesting, and I'll call them both the disgruntled whistleblower cases. We have a Royal Bank of Scotland case.
As opposed to the happy whistleblower case?
Well, I think when they get paid, they're a little happier, right? And then there's a Life Partners Holding case as well. Both of them would be big whistleblower payments. I think the RBS case is a $490 million payment that the whistleblower is seeking, and Life Partners Holding was a $1 billion amount that was, I guess, recovered through bankruptcy court. So, get 30% of $1 billion, right? That would be a significant whistleblower payment of $300 million. I think in 2022, the SEC paid, I think it's like $220 million and change in whistleblower payments. As we said earlier, there was one payment this year already of $279 million. But I think we have a lot of folks looking to take advantage as much as they can, or push their whistleblowing activities through the Dodd-Frank Act. And both the RBS case and Life Partners Holding, it was ultimately determined that the SEC didn't bring any action in those cases, so the whistleblower wasn't eligible under Dodd-Frank to recover their 10 or 30% of the amounts recovered.
And in the RBS case, I'm sure the would-be whistleblower thinks he was just a little bit too late or sent the information to the wrong place, because it was a case that was taken up by a mortgage-backed securities task force. He blew the whistle to the SEC. They passed along the tip. Then RBS reaches $1 billion settlement with the task force, and the SEC doesn't bring an action, so he doesn't have the covered action under 21F that would entitle him to an award. So good deed, no luck on the payment though.
And so, Kate, I think most of us in this room know better that our separation agreements should have or should not have certain language in them, but why don't you walk us through some of the 21F cases that we saw in the past year?
Sure. So let me start with Activision Blizzard. So in February of 2023, the commission announced settled charges against Activision, which is a video game development and publishing company. So it agreed to pay $35 million to settle charges that it failed to maintain disclosure controls and procedures to ensure that the company could assess whether its disclosures pertaining to its workforce were adequate. But it also did include a 21 F-17 component, which, as we mentioned earlier, prohibits taking any action to impede an individual from communicating directly with the SEC, the staff, about a possible securities law violation. So in that matter, the SEC's order found that between 2016 and 2021, Activision executed separation agreements in the ordinary course of its business that required former employees to provide notice to the company if they received a request for information from the commission staff. So kind of continuing in that theme, we can also talk about the Brinks case. So in June 2022, the commission announced settled charges against Brinks Company for requiring employees to sign restrictive confidentiality agreements prohibiting the disclosure of any financial or business information to third parties without an exemption for potential SEC whistleblowers. So in that matter, among other relief, the company paid a $400,000 civil penalty and agreed to undertake to amend its employment agreements to make clear that employees may report possible securities law violations to the SEC without prior company approval, or forfeiting any resulting whistleblower award, and to make reasonable efforts to contact current and former Brinks employees who had executed the confidentiality agreements and notify them that notwithstanding those restrictions, they may provide confidential information to the SEC staff and accept SEC whistleblower awards.
Great. So now that we've all kind of caught everybody up on the reading that probably, like in law school, I didn't always do, let's get into the hypotheticals and the fun stuff and the facts. So we've seen layoffs on Wall Street, and we've certainly seen layoffs here in the Silicon Valley area. And I think the folks on this panel agree that we expect there may be even some more whistleblowers coming out of the current economic environment. Justin, let's start with you being the person who's in-house. Walk me through what you do when you first get that whistleblower hotline call or tip. What are you thinking? Who are you calling first? Who are you not calling first?
Yeah, the bad news is I'm not calling my outside counsel first, but I do often or sometimes call them. I think the way I approach, so my team does work on submissions that come through the hotline. The way I approach them is you start with that golden rule that you work the problem, not the person. There's sort of two types of complaints that can come through the hotline, not substantively, but like from the person. One is an anonymous one, and one is where the person has disclosed their identity. And how you might work those two things and who you might speak to differ greatly depending on whether they're anonymous or not. The first person I want to talk to is the person who made the submission. They rarely present a nice legal memo with all the facts laid out and all the legal theories laid out, and sometimes it's just a couple of sentences, very similar to the TCRs you guys get often. And so that's the first person I want to speak to. And if they've disclosed their identity, that's an easy thing to do. If they haven't disclosed their identity, usually you can communicate back through the third-party vendor that we use to oversee our hotline. But that's not the best way to really communicate with someone. You're like trading emails. So I try to encourage the person to speak with me by telephone, and the technologies like Zoom and similar technologies allow you to do that anonymously. So I welcome the opportunity for people to speak with me anonymously, set up a Zoom link, you don't have to turn your video on, and we'll have a conversation. That's actually proven out to be pretty effective. Often people just say, I prefer not to. I'll send you documents or answer specific questions, and that's fine too. The second thing I want to do is really emphasize the company's policies on non-retaliation, on anonymity, confidentiality as best we can, because I want to give these people comfort that they can talk to me often, they can trust me as a partner, as someone who's independent in some respects of whatever the issue is that they're looking at. So those are the things that I'm generally thinking about at the front end. We try handle a lot of the work internally. We have a lot of internal experts, people who are at DOJ, at the SEC, people who've been very seasoned attorneys at private firms. And we usually speak with outside counsel for gut checks. And you know, one of the trickiest questions is like upjohn, and how do you approach that with someone who may be sensitive? But you know, you just sort of, you plan for it. You want to make sure you're privilege protecting your work. And those are a lot of the initial considerations I have. Just to your point about layoffs, though, Shannon, it's interesting that the UBS case involved someone who was laid off allegedly. That was the defense, and they still got a plaintiff verdict. So there is a question there about people who come forward in the climate of layoffs, and what companies have to do, and be hypersensitive about how you're approaching that on the employment side. So in-house, I will often work with our employment law team, our HR teams, particularly in this environment, to make sure that we're handling things from an employment side perspective appropriately, in addition to the substantive underlying concerns.
So then, assuming you bring in somebody like Britt, what are you thinking about when you get that call from a client in terms of next steps, and how you advise your clients on these tips?
Well, at the front end, before there's even a call that comes in, either internally or to me, I think it's important to remind clients that they want to set the tone at the top, that they want to create a culture of compliance. They want to have a code of conduct that if it's presented to them at investigative testimony or deposition, there aren't going to be good questions that would get good admissions coming out of that. So I think there's a whole compliance perspective that companies have to put in place before individual complaints even come in. So that's something that I always emphasize. But then once the complaint has come in, I think that focusing on doing a proper investigation, plus ensuring that there's not any retaliation or anything suggestive of retaliation, are important. And it's human nature. If a complaint's been made, people want to find out who it is. So I think that's the hardest thing for in-house lawyers to manage, is ensuring that the employees who may be involved or maybe contacted during the investigation aren't getting nosy about who may be the source of the tip. And so managing that piece of it is something that I always try to help clients navigate through. Because the worst case scenario would be to have a credible complaint that identifies some sort of misconduct at the company, and then have a follow-on retaliation issue coming out of that as well.
Yeah, I'll just add to that. For those reasons, I'll often in my initial communication put links to our anti-retaliation policies, and I will tell people I speak with, here's the policy. If you feel that's happening to you, that is a violation of our code of conduct, and you can report that to me as well. I want to hear about that. I want to make sure you're protected. One other thing neither of us actually talked about is the sort of maybe undercurrent concern: has this person already gone to the government? And you try to put that out of your mind, but it's a little like the human nature point you made about wanting to know who the person is and where they're coming from. You kind of might be worried, have they gone to the government or not? At the end of the day, I think, I'd be interested in your perspective, Britt, but from my perspective, the best defense if they've gone to the government is to have the facts really well developed and really well investigated. You don't know if they've gone, but if they have gone and the government knocks on your door, you just want to say, yeah, look how hard we looked at this and look at what we uncovered. And that's really where we get a lot of input from outside counsel.
And to that point, I think time is of the essence when a complaint comes in, because you don't know when the government is going to surface, and when the government surfaces, you want to have in hand a fully formed, privileged investigation where you know what the facts are before anyone is going out and speaking on behalf of the company to the government.
I would just quickly add there too, I think the government's now expanded to not only be the US government, but for a multi-jurisdictional company like Meta, you have the EU, which in 2019 rolled out their own whistleblower mandate. I think 21 of the 27 EU states have already issued their own rules around whistleblowing, reporting, and the like. So, you also worry, is it not only the US government, but some, foreign jurisdiction as well.
So Tom, talk to us about, or Britt, how do you get somebody like Tom, a forensic accountant, involved? And Tom, talk to us in terms of how you're looking at this. I always think of my forensic accountants being sort of my helpers in communicating with the auditors to the extent you need to keep them apprised and don't want them to ask you to boil the ocean again after you've already boiled it once. Where do you jump in? And
Sure. So I think both, I'll answer that, one as an auditor or a shadow investigator, which we call from the audit perspective, and then two, just from assisting outside counsel in the company with performing investigations. I think the number 4 most popular report to the SEC through the whistleblower program has been around financial disclosures, around financial reporting. And we've seen, particularly at KPMG, a pretty big uptick in accounting-related investigations. I think that's the home run for us as forensic accountants, right? When it's going to involve something that relates to financial reporting or internal control or disclosure. And I'd say between earnings management, channel stuffing, we've seen a lot of that recently. And almost, I think about 5 recent matters I've worked on, they've all come in through whistleblowing. Now, that's not necessarily SEC whistleblowing. It could be the internal hotline, could be a number of different ways, but we're definitely seeing a big uptick in that. And like I said, I think it's like 16 or 15% of the whistleblowing reports have been around that. I would say from an audit perspective, all the big 4 look at this a little differently, but your auditors are, and it kind of depends on the life cycle, right? You have a whistleblower complaint comes in, it could be frivolous, it could be something that is just made up, but so you got to look at it where it is in the life cycle and where the investigation is. But we're going to definitely be concerned as the forensic accountants come in and assist our auditors or our audit teams with is there any violations of law or regulation or legal acts? Who's involved? How far up the chain of command it goes? Is there a problem with tone at the top? I think Britt mentioned earlier. Is it material to your financial statements? Does it involve a rep letter signer? So anyone in management that would be signing a rep letter that they provide to the auditor. And then also just, could it lead to a problem where it needs to be disclosed in the financial statements or relates to a disclosure made in the financial statements or a restatement of your financial statements? Those are going to be the main things that us as forensic shadow investigators we look at. And we're going to need to get the answers to some of those questions if it's at the right time in the investigation prior to releasing our opinion on the financial statements.
Just to pick up on something you said about disclosure, the Activision case that you were discussing earlier had the whistleblower 21F confidentiality impediment issue, but it also had this disclosure issue where the main reason that Activision was tagged was that employees were making complaints or reporting misconduct within the company, and the violation that the SEC found was that those complaints were not being communicated to the disclosure people. So it was this weird intersection where there wasn't a meaningful substantive violation that the SEC was focusing on, but it was disclosure tied to internal reporting of complaints. And they didn't actually find any credible complaint that was even the focus, but it ties back to your disclosure point of when there's a whistleblower internal reporting issue, taking steps to ensure that that's being communicated to the appropriate people who have to make the disclosures.
Yeah, and I think Activision also, they didn't even have a process or a procedure to take in and actually monitor their whistleblower complaints. So, obviously that's a control failure.
And so, Kate, let's go back to you. From your perspective, how are you thinking about how a company responds to a whistleblower report?
So first, I would just like to say we definitely encourage self-reporting potential violations of the securities laws, and that means, you know, not waiting for the staff to ask about the problem and discover it, but actually, you know, true self-reporting and coming forward. There've been a number of cases recently in the last year where a company has self-reported a violation or otherwise proactively cooperated with the staff, and that led to a reduction in penalties or even no penalties at all. So certainly encourage that. And just kind of picking up on something, Justin, you mentioned about maybe that you have to think about maybe that person has already gone to the SEC or the government. So after Digital Realty, in which the Supreme Court held that a whistleblower must report directly to the commission a violation of the securities laws, I think that changes the incentive a little bit there. So I think, you know, companies should just assume when they're making this determination as to whether to self-report, assume the government already knows about it, because there really is an incentive to come forward. So, you know, we just also note, I think, you know, we certainly, retaliation is in looking into violations regarding anti-retaliation protections is certainly a priority for the Office of the Whistleblower. So certainly something that we look at there.
So when you hear that I send the policy people, do I get a thumbs up?
No comment.
And so, Britt, for many of our clients, the impact of a whistleblower goes well beyond dealing with our friends at the SEC. Can you talk a little bit about sort of the other ripple or tidal wave effects that we've seen it have?
Sure.
What are you thinking about there?
So I think that whistleblower allegations, when they're publicly reported, they have more of a gravitas or more of a sexiness about them that make the public pay attention, because it seems like there's an insider who's producing documents. It goes back to our Pentagon Papers and all of the things as Americans that we focus on. So I think if a whistleblower comes out and says something, it may get more attention than just the SEC independently undertaking an investigation to allegations. So that presents its own set of challenges for companies, as they have to manage the crisis communications. They have to anticipate other agencies, the plaintiffs' bar, Congress, piling on and getting involved in the matters as well. So a whistleblower action by an individual has the internal consequences, but can also create lots of other second-order effects. And now there's this phenomenon of the professional whistleblower, the celebrity whistleblowers you talked about. There are certainly people who are making a name for themselves by going out and making whistleblower allegations. So there's a lot of complex management issues there, because the company doesn't want to seem anti-whistleblower, doesn't want to seem to be retaliatory, but then at the same time, there's a lot of management that has to be done from a crisis communication standpoint when someone is going to testify before Congress, for instance, and the market cap implications for the company in those types of situations. So I think my overarching point is trying to manage every step of the process. So when you are in a negative situation, you have your good company story to tell. You have we send out the anti-retaliation policy. Our code of conduct lays out the reporting channels. So you are taking the focus off of the whistleblowing piece. That story is locked down and well-baked. So then you're just dealing with whatever the underlying allegations might be, because there are lots of different repercussions that can come out of a whistleblower allegation.
Yeah, it seems more and more it's the headline that is the sort of the real problem for some of our clients at this point, rather than all of the other things that go into responding to a whistleblower. Right. So, Justin, you don't have to comment on this, but I would imagine that somewhere in the playbook in-house there is a PR, talking to your PR part of the business in terms of how to get ahead of something that you think is going to come out.
Yeah, I mean, there's two dynamics there. One is often you don't know that it's coming. Like you get a little taken by surprise. That's in some ways the nature of of a whistleblowing allegation, and the company then has to decide how it's going to react. Legal is obviously involved in that process in-house. The worst thing you can do is say something that turns out to be incorrect, because then your reaction has generated a potential false statement. So legal is very involved. Investigations teams are very involved in understanding very quickly what might be happening. In terms of when you have an inkling something is coming, there's two parts to the calculus. One is very similar to the reactive, which is, making sure you're right, making sure anything you say is vetted. But then there's also the wisdom of making a statement. Do we need to speak about this at all? Should we speak about this at all? So those are the considerations, and I'm sure many people in this room counsel on those considerations from the outset of a whistleblowing allegation through an investigation and beyond.
And the commoning point, I think, is an important one, because oftentimes the inkling that companies get from this may be a press inquiry that goes to someone in the communications department or investor relations. It's like, oh, can you comment on and fill in the blank issue? And comments may be made, or the information may not be communicated within the company that these questions are being asked. So you lose that opportunity to get ahead of it and know that something is coming, so you can be offensive as well as defensive. So I think that goes back to having a culture within the company that is communicative, and having people at all levels of the company and all departments understand how they intersect with one another.
Great. So I want to wrap it up with a question that we got came in from the audience in anticipation of this panel, and it shifts the perspective a bit, and is from the person who is counseling or representing a whistleblower. And the hypothetical goes as follows. There's a parallel investigation, SEC and DOJ. You are representing a whistleblower who is close to the purported violation. And the question is, should you get a proffer for that person? And if you get a proffer for that person, will that impact the whistleblower award? And so thank you, whoever threw that question at us.
Jacob Frankel.
Thank you. And Justin, we're gonna let you talk from experience here.
Yeah, I mean, your first duty is to your clients. So if you need a proffer agreement for your client, you get a proffer agreement for your client. I think that part is easy, and it's, even if your client is not necessarily culpable, that can be very protective. And if they're nervous, it might give them comfort to speak more and offer more information in the room with, I'll just say, the SEC, because that's where I was at, but I'm sure with the DOJ too. So I think, yes, there's very little downside in representing your client against jeopardy to getting a proffer agreement. In terms of the impact on the whistleblower award, it's a 10 to 30% range. You're not trying to maximize your dollars. You'll get some dollars. There are factors that the commission considers in deciding what sort of award should be granted. Culpability is one of those factors. If you need a proffer and you had some culpability, maybe that would be a downward factor, but it would be a downward factor without the proffer agreement. So I wouldn't overweight too much the impact on the whistleblower award of asking for a proffer agreement. I would focus on the ability to allow free communications, and candid communications, and your duty to your client. Anyone have a different view?
No, I agree. Although I'm not a whistleblower, so I'm not thinking about it in the same sort of cost-benefit analysis. I think if somebody has their eyes on the wrong prize, the money, right, then it may be hard to talk them into getting a proffer if what you think could happen is it could impact the award.
Yeah, I mean, one of the criteria for getting an award is that you voluntarily are producing the information.
Correct.
So I suppose someone could argue, well, we had to give you the proffer, otherwise you wouldn't have voluntarily produced. But I think at the end of the day, the proffer is a tool to encourage more voluntary disclosure. That's how I view it.
And I think the culpability factor is going to be what it is, regardless, as you said.
So do we have any questions from the audience? Anything for this wonderful panel? Otherwise, I think we're ready to wrap? No? Bruce, any questions from you?
I'm sorry, I don't have one for you.
Okay.
You finished?
Yeah, we are.
Okay.